This is a lecture on assault. Now, assault is defined in the secondary statement as intentionally causing apprehension of harmful or offensive bodily contact. The problem that people have with assault is the state of mind. And the reason of this problem is because there are two states of mind required for assault, and people try to fit it into one. The two states of mind are shown here. First, the person must intend an act, and that act which they intended must be the actual and proximate cause of the apprehension. But in addition to intending the act, and by intending the act, what I mean is blinking an eye is a reflex action that's not treated as an intentional act. But if you are falling to the ground and you put your arm out to brace the fall, that's an intentional act because it went from your brain out to your muscles, and that's intentional. And so not reflex things. If a person is ill and their body moves as a result of the illness, that's not an intentional act. But we're talking about where you intentionally do the act, whatever that act is. You move your hand, reach in the pockets for the knife, any kind of a movement. So you need that movement. That can be a movement plus some words. And that movement, with or without the words, must, if it has words, then the movement and words must be the actual and proximate cause of the apprehension. And now the second state of mind that is required for assault is intent to cause that apprehension, or intent to touch, either way, the intent to actually touch them or to cause the apprehension. So the defendant needs to have two states of mind: intent to do the bodily act and intent to cause the apprehension, or to actually touch. Now, the issues that arise on each of these parts are as follows. First, the intent to act. We understand what that is. No eye blinking here. The general rule is that words alone will not do. You need an act. So that a person who sits at the car seat with their arms folded looking straight ahead and says, "I am going to kill you with my machine gun right now." Okay, and that clearly is not an assault. You need an act. Now, if the person reaches in their pocket and makes some movement where it's reasonable to believe that you now may get hit, then that will be a sufficient act. Words alone generally are not enough. Got to do something. Now, we know that there are a couple of exceptional situations where words alone are enough, probably. Someone is standing on the edge of a cliff and their back is turned to the cliff and you're making photographs, and you say to the person, "You're not quite in focus, go back about 3 feet." And the person's only 1 foot from the edge of the cliff and they don't know that. And you do this with the intent to make them fall over the cliff. That's words alone. And you can think of these freaky situations where words alone will do. But outside of those kinds of odd situations, words alone will not do. You've got to do an act. You've got to move the hand towards a gun, towards a knife, or do whatever you're going to do. Next, conditional words. Now, if the person moves their hands towards a sword and says, "If this weren't Thursday, I'd run you through with my sword." Well, it is Thursday in this hypothetical. And so that conditional threat should not give the person reason to believe that they're going to be touched. So you will not get an assault if you have conditional words that negate the intent to do it right now. However, sometimes these conditional threats might be a person is robbing a bank, and they point a gun at someone. They say, "Move over there." Well, the person is impliedly saying, either you move over there or I might shoot you. And so that's a conditional threat. But the way you look at these is you ask, did the person have the legal right to impose the condition? And if they did not have the legal right to impose the condition, you just ignore the condition, and now it becomes a threat, becomes an assault, because the person thinks they're going to be injured. Even if the person has the legal right to impose the condition, you can't use unreasonable threat of force to do that. For example, a person has just gotten fired from his job, and the person who fired him says, "Now get off the premises right now." Well, sure, you have a right to tell the person to get off the premises. No problem. But suppose you pull out a gun and point it at the person and say, get off the premises right now. Well, that's threatening excessive force. That will turn out to be an assault. Okay? Now, so next, the actual and proximate cause, that whatever the act is, it must cause the apprehension. And if, for example, the person who is saying using words and even doing an act, if they don't even appear to have the means to carry it out, that's not going to work, because you shouldn't think you're going to be touched. It doesn't. If I say I'm going to kill you with my machine gun and I'm standing here naked, well, that's ridiculous, even if I make some motions. And so they have to at least appear to have the means to carry out the touching. And also, if I've got a gun here, and if I have the gun and I know it's in, I point the gun at someone and I say, I'm going to shoot you. Okay, that's obviously an assault. But let's suppose that the gun is empty, so I really can't shoot them. And they don't know that. And so, of course, that doesn't matter. It could still cause the apprehension. But suppose that person knows the gun's empty. Okay? And the rule is, in that case, there is no assault. Now, and finally, the act must cause the apprehension of harmful or offensive contact. We use objective standards here. That is to say, the act must be one which would cause the apprehension of a reasonable person. Now, if you're talking about a hypersensitive person, it's not a question of whether or not this particular person, the rule is not about that person subjectively having the apprehension. The rule is, would this have caused apprehension in a reasonable person? That's the standard. Fear is not the same as apprehension. You don't need fear, just apprehension. The timing must be immediate in the sense that the person must think they're going to be touched right now. And if you say, look, I'm going to go out in my car, get my gun, and come back here and shoot you, you're not going to get an assault out of that because it's not immediate enough. Next comes the case where of known high sensitivity. I am the person acting, and I know that this person over here is very sensitive to certain things that other people would practically ignore. So I do this thing with the intent to create the apprehension. Okay? But it wouldn't have created apprehension in a reasonable person. What happens in that case? And there's a split of authority about that. The restatement takes the position that if you really intended to cause apprehension in this person, and you did it, no matter how little you did, and you did it and got the apprehension, that should be an assault. Okay, but that doesn't follow the general rule that what you do has to be enough so that a reasonable person would be offended. And the fact that this person is hypersensitive is irrelevant, and even if you know they're hypersensitive, the restatement doesn't deal with that. Finally comes the awareness issue. In the case of apprehension, of course, you have to be aware that you're about to be touched, whereas in the case of battery, you don't really have to be aware of it, and this awareness is required. So we see then that for this pathway here, the person needs to intend an act. That act must be the actual and proximate cause of the apprehension. And here are some comments about the apprehension itself. The second pathway that is going on simultaneously in these problems is the intent to cause the apprehension or the touching. Either one will do. The intent to cause the act, so that the person who is committing the assault has to have the intent to do the act and the intent to cause either this results or that results. Under here, the issues which get tested are, first of all, that substantial certainty is a substitute for intent. That is, if you do something and you're substantially certain of what the results are going to be, that's the same as intending that result. But this substantial certainty is different from just a high probability. Okay? Substantial certainty will replace intent. High probability will not. So if someone is sitting down and halfway through their sitting down motion, you pull the chair from under them. you're substantially certain that they're going to hit the floor. And if you, and it's just that kind of substantial certainty that takes the place of intent. High probability, you have to go to negligence for that. Next, under this intent to cause the touching or the apprehension, insane people and minors can commit assault because the reason is that you don't require much the state of mind is pretty simple. If you intend to do the body movement, and minors and insane people can intend to do the body movement, and if you intend to make that person think they're going to get hit, okay, well, crazy people can do that, and minors can do that. And so that's not a defense. Finally comes the transferred intent issue. Now, we have a problem here because some sources say, if we go back to Prosser's original Torts book, it said that you should be able to transfer intent among the 5 common law torts: assault, battery, trespass to land, trespass to chattel, and conversion. And Prosser says that if you have the intent to do any one of those and you end up doing one of the other ones, that the intent to do the first one is enough to satisfy the requirements of the second one. And even if you intended to do it to one person, you did it to someone else, you can transfer intent from person to person and tort to tort. And in his first edition, he said you could do that you should be able to do that among all 5 of the common law intentional torts that I just listed. In his second edition, Prosser changed his mind, and he said, I don't think so anymore. I think that you should be able to transfer intent between assault and battery, but I'm not so sure about the others. And so what happened then is that some places you will see, like in the bar outlines, you will see that they generally say that you can transfer intent among all 5 of the common law torts, and from person to person also. The second restatement says you can transfer intent between assault and battery, but that's all. Prosser now says you can transfer between assault and battery, and he's not so sure about the others, what the policy ought to be about the others. And for bar purposes, you just discussed them all. Now, so let me summarize what we have regarding law of assault. The person, there are 2 intents required: intent to do the act, and the act, you can have words plus the act, or the act must be the actual and proximate cause of the apprehension. And in addition to that, the person must intend to cause the apprehension or to cause the actual touching. Substantial certainty will replace intent, and these other comments that we just made here about the intent to cause the apprehension. That is more than you need to know about the law of assault, and you should do well with that knowledge on an examination. That's the end of this lecture.